continuing the training with Part 2. Again, training was built around the guidance in PIH's Notice 2017-08, published on May 19, 2017. As such, the training agenda follows the order of PIH Notice 2017-08 unless we say otherwise. Anytime we use the term notice, we are referring to this specific PIH notice on VAWA. We have already gone over the first 7 chapters. Now, let's take a look at the next 4, sections 8 through 11 of the notice. The VAWA Final Rule has specific requirements for certification and documentation of domestic violence, sexual assault, dating violence, or stalking. The notice transmitted the certification form, Certification of Domestic Violence, Dating Violence, Sexual Assault, or Stalking, and Alternative Documentation, also referred to as Form HUD 5382. PHAs must include HUD Form 5382 with the VAWA Notice of Occupancy Rights, also referred to as HUD 5380. These forms are available at hud.gov/HUDclips. Please note that under the Mod Rehab program, a PHA may provide Form HUD 5382 to owners and charge owners with distributing it to tenants along with the VAWA Notice of Occupancy Rights. Please note, Form HUD 50066, Certification of Domestic Violence, Dating Violence, Sexual Assault, or Stalking, previously used for the public housing and housing choice voucher programs to serve as a means of documenting the incident or incidents of domestic violence, dating violence, sexual assault, or stalking, is now obsolete. Now let's take a look at the new HUD 5382 form, the Certification of Domestic Violence, Dating Violence, Sexual Assault, or Stalking, and Alternative Documentation. The form states that VAWA 2013 protects applicants, tenants, and program participants from being evicted, denied assistance, or terminated from housing assistance based on an act of domestic violence, dating violence, sexual assault, or stalking. It is an optional way for victims to comply with a written request for documentation about the incident or incidents of domestic violence, dating violence, sexual assault, or stalking for the person seeking VAWA protections. It allows that the victim or someone on the victim's behalf may complete the form. It includes a list of third-party documentation to satisfy a request by a PHA or owner for documentation. It explains the time period for responding to a written request for documentation, describes the confidentiality protections under VAWA, requires that the victim or someone filling out the form on the victim's behalf must answer 10 numbered questions and provide a brief description of the incident. It clarifies that the name of the accused perpetrator does not have to be provided if it is unknown to the victim or if it cannot be provided safely. It clarifies the date and time of the incident should only be completed if known by the victim, and it requires the victim or someone filling out the form on the victim's behalf to certify to the truth and accuracy of the information being provided, and explains that false information could be the basis for denial of admission, termination of assistance, or eviction. HUD encourages PHAs and owners to advise that when a PHA or owner receives the form submitted on their behalf, such submission will take the place of their own statement. Thus, applicants, tenants, or program participants should ensure, to the extent possible, that the information is accurate and comprehensive. The Form HUD 5382 must be made available by the PHA in multiple languages, consistent with HUD's limited English proficiency guidance. You can find those forms available on HUDclips in Armenian, Cambodian, Creole, Japanese, Korean, Lao, Mandarin, Russian, Spanish, Thai, and Vietnamese. In addition, when obtaining information through the form and consistent with civil rights requirements, PHAs must take appropriate steps to ensure effective communication with applicants, tenants, and participants with disabilities through the use of appropriate auxiliary aids, services such as large print and braille documents, readers, interpreters, and accessible electronic documents. PHAs must provide reasonable accommodations when necessary to allow tenants, participants, and applicants with disabilities to equally benefit from VAWA protections, such as providing individualized assistance in completing forms. Ryan, could you give us more detail about the different types of documentation?
Sure, I'd be glad to. HUD does not require PHAs and owners to ask for documentation, and as such, they may choose to accept a verbal statement or other corroborating evidence. HUD recommends that PHAs and owners develop written policies for how and under what circumstances a verbal statement will be accepted, such as when the PHA was aware of the abuse and encouraged the victim to request VAWA protections. It is recommended that in cases where PHA or owner decides to rely on such information, the PHA or owner document in a confidential manner the individual's verbal statement or other corroborating evidence. Now let's take a look at requesting documentation. If the PHA or owner chooses to request an individual to document their claim of domestic violence, dating violence, sexual assault, or stalking, the PHA or owner must make such request in writing. Simply providing the victim Form HUD 5382 does not constitute a written request for documentation unless the Form HUD 5382 is accompanied by a dated letter requesting documentation. When a PHA or owner requests documentation, an individual may satisfy this request by providing any one of the following documents. Form HUD 5382, which is the certification of domestic violence, dating violence, sexual assault, or stalking, and alternative documentation. A document that is signed by an employee, agent, or volunteer of a victim service provider, an attorney or medical professional, or a mental health professional from which the victim has sought assistance. It's signed by the applicant or tenant, and that specifies under penalty of perjury that the professional believes in the occurrence of the incident is grounds for VAWA protections and that the incident meets the HUD-defined definition of domestic violence, dating violence, sexual assault, or stalking. A record of a federal, state, tribal, territorial, or local law enforcement agency, which may include a police report, court, or administrative agency, or at the discretion of the covered housing provider, a statement or other evidence provided by the applicant or tenant. The PHA or owner must accept any of the above items noted on the slide A through C as provided under 24 CFR 5.2007. For example, Form HUD 5382 must be accepted in lieu of any of the third-party documents outlined on the slide B or C if the individual chooses to self-certify the PHA or owner's request for documentation, and the submitted documentation does not contain conflicting information. Going into more detail, remember, a PHA and owner have the discretion to accept the statement or other evidence. HUD encourages PHAs to develop written policies as to whether they will exercise discretion. PHAs are encouraged to note whether a statement or other evidence will be accepted. If other evidence will be accepted, HUD recommends that the PHA or owner define acceptable evidence. The PHA or owner is prohibited from requiring third-party documentation of victim status, except as outlined in 24 CFR 5.2007. and described further in Section 8.2e of the VAWA notice. Given the possible consequences to both the victim and the alleged perpetrator of domestic violence, dating violence, sexual assault, or stalking, it is important that any allegations made by one individual against another are made with the understanding that there are consequences if the allegations are false. In this regard, Form HUD 5382 advises that the submission of false information may be a basis for denial of admission, termination of assistance, or eviction. Randa, can you discuss time to submit documentation?
Okay, now let's discuss timelines. When requesting documentation, a PHA may require submission within 14 business days after the date that the individual received the written request. After 14 days, the PHA or owner may extend this time period at its discretion. Some things to remember. Requests for documentation should be made in writing, and PHAs or owners are encouraged to acknowledge receipt of the documentation in a timely manner. During the 14 business day period and any granted extensions of that time, no adverse actions such as eviction or termination can be taken against the individual requesting VAWA protection. For example, PHAs must not schedule an eviction, grievance hearing, informal review, or informal hearing to take place during this time. In determining whether to extend the 14 business day period, PHAs and owners are encouraged to consider factors that may contribute to the victim's inability to provide the documentation in a timely manner. These factors may include, but are not limited to, cognitive limitations, disabilities, limited English proficiency, absence from the unit due to hospitalization or time in an emergency shelter, administrative delays in obtaining police or court records, the danger of further violence, and the victim's need to address health or safety issues. PHAs and owners must also grant reasonable accommodations for persons with disabilities. Please note that because of these factors, the PHA or owner might not be contacted by the victim with a request to extend the 14 business day period until after the 14 business day period has passed. Once a victim provides documentation of domestic violence, dating violence, sexual assault, or stalking, the PHA or owner is encouraged to acknowledge the receipt of the documentation in a timely manner. If the applicant or tenant fails to provide documentation that meets the criteria within 14 business days after receiving the written request for that documentation, or within the designated extension period, nothing in the VAWA final rule limits the denial of admission by the applicant or tenant to the housing or program. Denial of assistance under the covered housing program to the applicant or tenant, termination of the participation of the tenant in the covered housing program, or eviction of the tenant or a lawful occupant that commits a violation of the lease. An individual's failure to timely provide documentation does not result in a waiver of the individual's right to challenge the denial of assistance or termination, nor does it preclude the individual's ability to raise any incidents of domestic violence, dating violence, sexual assault, or stalking at eviction or termination proceedings. If the PHA denies VAWA protections, it must still follow its established procedures for grievance hearings, informal hearings, or informal reviews. When an applicant or tenant requests protection under VAWA, the VAWA final rule allows, but does not require, the covered housing provider to require the applicant or tenant to submit documentation of victim status, that the applicant or tenant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. However, the VAWA final rule prohibits a covered housing provider from requiring the victim to provide third-party documentation of victim status unless under these two circumstances. A, more than one applicant or tenant provides documentation to show they are victims of domestic violence, dating violence, sexual assault, or stalking, and the information in one person's documentation conflicts with the information in another person's documentation. Or B, submitted documentation contains information that conflicts with existing information already available to the PHA or owner. In these circumstances of conflicting documentation, we again refer back to the regulations for documentation at 24 CFR 5.2007B1 for a list of criteria an applicant or tenant may submit to meet the third-party documentation request. Note, on the list you will not find Form HUD 5382. Since 5382 is self-certified, the A through C documents listed here may be used to satisfy a request for third-party documentation. And remember, This is only when there are cases of conflicting documentation as mentioned in the previous slide. The applicants or tenants must be given 30 calendar days from the date of the request to provide such documentation. Please take note that if an applicant or tenant responds with a third-party documentation that meets the criteria above and supports the applicant or tenant's VAWA request, the PHA or owner is prohibited from requiring further documentation of the applicant or tenant's status as a victim of domestic violence, dating violence, sexual assault, or stalking. However, if an applicant or tenant does not submit any third-party documentation within the required time period or submits documentation that does not meet the criteria above, the PHA or owner may, but is not required to, accept that applicant or tenant's assertion of victim status for the purposes of VAWA protection. For the purposes of providing VAWA protection, satisfying the documentation requirements as previously mentioned resolves the question of whether the applicant or tenant is a victim of domestic violence, dating violence, sexual assault, or stalking. Please note that in the cases of conflicting documentation between two tenants, if one tenant submits a court order addressing rights of access or control of property, such as a protection order granting the victim exclusive possession of the unit, the PHA or owner must honor this court order. When requesting third-party documentation, the PHA is encouraged to provide contact information for local domestic violence agencies so that the applicants or tenants can seek services and plan for their safety. Additionally, it may be helpful to include contact information for those legal aid offices, which may be able to assist in providing appropriate referrals, obtaining restraining orders, and preparing for grievance hearings. If the PHA or owner requests but does not receive third-party documentation, the PHA or owner has the option to deny VAWA protections and must notify the applicant or tenant. If this results in a tenant being terminated from assistance, the PHA must hold a separate informal grievance hearing in public housing or an informal hearing in housing choice voucher for the tenant. When denying VAWA protections, the PHA or owner must ensure that it complies with PIH Notice 2015-19, which is Guidance for Public Housing Agencies and Owners of Federally Assisted Housing on excluding the use of arrest records in housing decisions. Alternatively, the PHA may have a family breakup policy allowing for assistance to be provided to both persons seeking VAWA protections. Here is an example where a PHA or owner may request third-party documentation. A two-person household was notified by an owner that they were being evicted from their unit due to a history of neighbors having to call the police for loud disturbances coming from the tenant household's unit, in violation of their noise provision in their lease. Each member of the tenant household provides certification to the owner that they are the victim of domestic violence and the disturbances arose from their partner's abuse. The owner has a policy of requesting third-party documentation when there are conflicting certifications. Thus, the owner requests third-party documentation individually from both members of the household. Within 30 calendar days, the owner receives third-party certification from only one member of the household. The owner treats the household member that submits third-party documentation as a victim of domestic violences for purposes of VAWA and notifies the other household member who did not submit third-party documentation that the owner has denied VAWA protections for the other household member. The owner must notify the household member being terminated from assistance and hold the appropriate hearing. Please note, perpetrators sometimes obtain temporary restraining orders or file police report against victims as a form of retaliation. Further, many victims are unable to timely access the courts or law enforcement due to language barriers, disability, cultural norms, or fear for their safety. As a result, the fact that only one party submitted third-party documentation is not always a reliable indicator of domestic violence, dating violence, sexual assault, or stalking. Additionally, an individual may satisfy a request for victim status documentation by submitting any document that meets the criteria under 24 CFR 5.2007b1. This is an important note to elaborate on. The PHA or owner must accept the submitted documentation and is prohibited from seeking additional documentation of victim status unless the submitted documentation does not meet the criteria in the VAWA rule or the submitted documentation contains conflicting information, including conflicting claims between the two parties as discussed in the example. Additionally, PHAs and owners are prohibited from conducting further fact-finding for the purpose of trying to verify the validity of an applicant or tenant's victim status. For example, PHAs and owners are prohibited from conducting interviews with neighbors or employers to determine if the applicant or tenant is really a victim of domestic violence, dating violence, sexual assault, or stalking. Doing so would be in violation of the documentation requirements of the VAWA final rule and may result in violation of the victim's confidentiality requirements of the VAWA final rule. However, if the PHA or owner already has or regularly receives reliable information that conflicts with the submitted documentation, the PHA may require third-party documentation of victim status based on information outside of the submitted documentation. Examples of reliable information might include surveillance footage, police reports, and other verifiable information. This information must not be collected for the purposes of discrediting claims for VAWA protections, but may be collected for other legitimate reasons, such as addressing safety in the community. If the applicant or tenant subsequently does not submit third-party documentation or only submits third-party documentation that contains conflicting information, the PHA or owner has the option to deny VAWA protections and must notify the applicant or tenant. Given the possible consequences to both the victim and the alleged perpetrator of domestic violence, dating violence, sexual assault, or stalking, it is important that any allegations made against one individual against another are made with the understanding that there are consequences if the allegations are false. To this end, Form HUD 5382 advises that the submission of false information may be the basis for denial of admission, termination of assistance, or eviction. The VAWA regulations include mandatory policies that must be included in applicable policy documents. The VAWA guidance walks through what information must be included in both public housing and housing choice voucher written policies. This chapter and the presentation will go into detail about each of these program documents. And at the end of the presentation and in Appendix 1, HUD has provided a helpful chart to summarize VAWA mandatory and discretionary policies. Let's begin with the 5-year and annual plans. PHAs are required to include a brief description in their annual plan, as applicable, and 5-year plan of goals, activities, objectives, policies, programs, or services for child and adult victims of domestic violence, dating violence, sexual assault, or stalking. The VAWA final rule did not change this requirement. Please be aware that the availability of new PHA annual and 5-year plan templates that include provisions of the VAWA 2013 were first made available through Notice PIH 2015-18. HUD encourages reference to the PHA's emergency transfer plan, and all PHAs are required to submit a 5-year plan for HUD's approval. MTW agencies or Move to Work PHAs are exempted. To PHAs who submit an annual plan, please note that the annual PHA plan templates require PHAs to report any changes to the plan elements which include VAWA. It's specifically under the safety and crime prevention element. The following list of elements must be included: a statement of any domestic violence, dating violence, sexual assault, and stalking prevention programs, a description of any activities, services, or programs provided or offered by the agency, either directly or in partnership with other service providers, to child or adult victims of domestic violence, dating violence, sexual assault, or stalking, a description of any activities, services, or programs provided or offered by the PHA that help child and adult victims of domestic violence, dating violence, sexual assault, or stalking to obtain and maintain housing, a description of any activities, services, or programs provided or offered by a PHA to prevent domestic violence, dating violence, sexual assault, or stalking, or to enhance victim safety in assisted families. While PHAs are not required to provide services or activities beyond the victim protections and remedies included in the VAWA final rule, HUD encourages PHAs to develop strategies and relationships with community organizations, domestic violence victim advocates, and local law enforcement to provide services and resources to victims of domestic violence, dating violence, sexual assault, or stalking as described in detail in Section 14 of this notice. For example, a PHA may partner with a local domestic violence service provider to offer a workshop to educate tenants and participants about their VAWA rights or other rights available to tenants and participants under state and local domestic violence laws or programs. If the PHA so chooses to partner with a domestic violence service provider, HUD recommends that these services and activities should be included in the annual plan as applicable in the 5-year plan. Ryan, can you walk us through the applicability or exclusion of such requirements for certain PHAs?
Absolutely. Okay, so here we have a chart broken out by qualified, small, HCV only, and MTW PHAs, and the impact that their designation has on the requirement to comply with the annual plan submission requirements of VAWA. While qualified PHAs must comply with 5-year plan submission requirements, nothing in VAWA 2013 or in the VAWA final rule supersedes the Small Public Housing Authority's Paperwork Reduction Act exemption of qualified PHAs from preparing and submitting an annual plan. As such, qualified PHAs are not required to comply with the annual plan submission requirements of VAWA. PHAs that meet the definition of small PHA and are using the streamlined annual PHA plan template are not required to submit the VAWA annual plan information. Housing Choice Voucher only PHAs using the streamlined annual PHA plan template for PHAs that only administer a Housing Choice Voucher program are not required to submit the VAWA annual plan information. Finally, PHAs that participate in the Moving to Work demonstration are not required to complete the annual and 5-year PHA VAWA requirements. Instead, MTW PHAs complete annual plans and reports as required in HUD Form 50900. MTW PHAs must otherwise comply with the requirements of VAWA. The administrative plan. The administrative plan states PHA policy on matters for which the PHA has discretion to establish local policies. PHAs must include in the administrative plan any local PHA policies regarding domestic violence, dating violence, sexual assault, or stalking that are not already explicitly required by the VAWA final rule. The VAWA final rule retains the provisions of HUD's regulations implementing VAWA 2005, which requires the description of specific protections afforded to victims of domestic violence, dating violence, or stalking must be included in the Housing Choice Voucher Tenancy Addendum and the Housing Assistance Payments Contract. See 24 CFR 5.2005A4. The Housing Choice Voucher Tenancy Addendum, Form HUD 52641A for tenant-based assistance, Form 52530 C, for project-based assistance, the HAP contract for tenant-based assistance, Form HUD 52641, and the PBV HAP contract, Form HUD 52530A and 52530B, will be revised to include the updated provisions of 24 CFR Part 5, Subpart L. The HAP contract for manufactured home space rental, or Form HUD 52642, does not currently include VAWA provisions and will be revised at a later date to include the provisions. PHAs continue to use the current version of these forms until the HUD update is complete. PHAs do not alter these forms or add their own addendum to the HAP contract or tenancy addendum in the interim. Miranda, can you provide public housing context to the documentation requirements?
Public housing has two main documents associated with VAWA reporting. First, the Admissions and Continued Occupancy Plan, or ACOP. A PHA's ACOP states the PHA's policy on matters for which the PHA has discretion to establish local policies. PHAs must therefore include in the ACOP any PHA policies regarding domestic violence, dating violence, sexual assault, or stalking that are not already explicitly required by VAWA Final Rule and further explained in this guidance. Second, the public housing lease. The VAWA Final Rule retains the provisions of HUD's regulations implementing VAWA 2005, which requires that a description of specific protections afforded to victims of domestic violence, dating violence, or stalking must be included in the public housing lease. PHAs must ensure that public housing leases contain the updated provisions of the VAWA Final Rule, including definitions, VAWA protections, documenting the occurrence of domestic violence, dating violence, sexual assault, or stalkings, and remedies available to victims of domestic violence, dating violence, sexual assault, or stalking as applicable to the public housing program, including emergency transfers. PHAs are encouraged to include in the lease any additional protections made available to victims of domestic violence, dating violence, sexual assault, or stalking. The VAWA Final Rule also revises the requirements for the notice of VAWA rights and includes a notification of occupancy rights under the Violence Against Women Act, also referred to as HUD Form 5380, and just simply Notice of Occupancy Rights. The VAWA Notice of Occupancy Rights is for use by all HUD-covered programs, including public housing, housing choice voucher, and project-based voucher. Please take notes that PHAs, not owners, are the covered housing provider responsible for this activity. However, under the Mod Rehab program, the PHA may provide the VAWA Notice of Occupancy Rights to owners and charge owners with distributing the notice and form to tenants. PHAs must issue the VAWA Notice of Occupancy Rights without changes to the core protections and confidentiality rights in the notice, and they must customize to reflect the specific assistance provided under the particular covered housing program and to their program operations that may pertain to or affect what is included in the VAWA Notice of Occupancy Rights. Again, this form can be found on HUD.gov/HUDclips, and it must be made available in multiple languages, which are also provided there. Form 5382, the VAWA Notice of Occupancy Rights, must be provided to adult applicants of public housing, housing choice voucher, and project-based voucher programs, and each adult tenant of public housing, housing choice voucher, and project-based voucher adult participants. Please be aware that the times for the notification of occupancy rights has changed for PHAs. The final rule now requires that the VAWA Notice of Occupancy Rights, HUD Form 5380, must be provided no later than each of the following times. For applicants, the form must be provided 2 times, at the time an individual is admitted to the program, and at the time an applicant is denied assistance or admission. For current tenants or participants, the form must be provided with any PHA notification of eviction or termination of assistance and by December 16, 2017. This means that PHAs have a full year after the final rule was published to administer this form. So PHAs will either have to give the form out during the PHA annual recertification or lease renewal process. Or if there will be no recertification or their lease renewal during the first year, the PHA must distribute through other means as determined by the PHA.
Thanks, Miranda. Let's begin to look at victim confidentiality. It is critical that covered housing providers establish or update existing policies to maintain the confidentiality and privacy of victims who seek protections under the VAWA final rule, given the significant safety issues faced by victims. The VAWA final rule clarifies that any information submitted to a covered housing provider, including the fact that an individual is a victim of domestic violence, dating violence, sexual assault, or stalking, must be made in confidence by the covered housing provider. Therefore, A, employees of the PHA or owner or those who administer assistance on their behalf, such as contractors, must not have access to the information unless explicitly authorized by the PHA or owner for the reasons that specifically call for these individuals to have access to such information under applicable federal, state, or local law. For example, the information is needed by a PHA employee to provide the VAWA protections to the victim. And B, the PHA or owner must not enter this information into any shared database or disclose this information to any other entity or individual, for example, a prospective owner of participants' unit, except to the extent disclosure is 1, requested or consented to in writing by the individual, the victim, in a time-limited release, 2, required for use in an eviction proceeding or hearing regarding termination of assistance from the covered program, or 3, otherwise required by applicable law. The prohibition against entering this information into any shared database does not preclude a PHA or owner from entering this information into a database system used by the PHA or owner that meets all requirements for securing sensitive personally identifiable information, or PII, including the Privacy Act of 1974, as long as the requirements listed previously and provided at 24 CFR 5.2007C are also met. For example, the victim consents to in writing in a time-limited release. For additional guidance on maintaining confidentiality, see Notice PIH 2015-6, HUD Privacy Protections Guidance for Third Parties. When communicating with an applicant, participant, or tenant who has requested VAWA protections, the covered housing provider must take precaution to avoid inadvertent disclosure of confidential information to another individual or entity in violation of the regulation. Unless given permission from the victim to do so, the PHA or owner must not leave a message that contains confidential information or refer to VAWA, the VAWA protections, or the domestic violence, dating violence, sexual assault, or stalking on the victim's voicemail system or with other individuals, including members of the victim's household. For example, asking the victim to come to the PHA to pick up Form HUD 5382. Leaving a voicemail requesting that the victim contact the PHA or owner without referencing VAWA, VAWA protections, or domestic violence, dating violence, sexual assault, or stalking is not prohibited. A best practice is for PHAs or owners not to send mail regarding the domestic violence, dating violence, sexual assault, or stalking to the victim's address if the perpetrator may have access to the victim's mail. For example, a covered housing provider may not send a written request to complete HUD 5382 or extension of the 14 business day timeframe to respond to the PHA's request for documentation through the mail, as a perpetrator may be the co-head of the household or is employed at the residency of the victim. The VAWA final rule is silent on how a PHA or owner is to balance the confidentiality requirements in the regulation with the requirements at 24 CFR 5.2007A when requesting documentation of occurrence of domestic violence, dating violence, sexual assault, or stalking in writing. PHAs and owners may determine the procedures for requesting documentation in writing on a case-by-case basis or adopting a general policy guidelines for how to handle these requests. For example, requiring the individual requesting VAWA protections to come to an office or other space that may be safe for the individual to receive the VAWA request, making reasonable accommodations as necessary. If the victim gives the PHA or owner permission to contact them about the domestic violence, dating violence, sexual assault, or stalking via mail, voicemail system, electronic mail, or other method approved by the victim, best practice would be to ensure this permission is in writing. If it is not feasible for the victim to provide the permission in writing, the PHA or owner may make note in the victim's file about which forms of communication the victim have been approved. The written permission or other notation must be kept confidential. When discussing these matters directly with the victim, PHAs and owners must take reasonable precautions to ensure that no one can overhear the conversation. For example, PHA employees are encouraged to make the documentation request in a private room, not in an open space at the PHA. PHAs and owners may require that the victim come into the office to pick up the certification form and are encouraged to work with tenants to make delivery arrangements that do not place the victim at risk. Something important to keep in mind is that the covered housing provider must comply with all non-discrimination and civil rights statutes and requirements in implementing their policies. This includes, for example, providing reasonable accommodations to permit individuals to follow or access any rules, policies, practices, or services, such as modifying a policy requiring that the victim come into the office to pick up the certification form to instead deliver the form to the victim. This also includes ensuring effective communication with persons with disabilities, such as providing sign language interpreters for persons who are deaf, accessible documents and assistance filling out forms for persons who are blind or have low vision, and providing language assistance for persons with limited English proficiency. PHAs and owners may suggest, but cannot require, that the victim designate an attorney, advocate, or other secure contact for communications regarding their request of VAWA protections. This may reduce the PHAs or owners' burden in ensuring confidentiality communications with the victim. The following best practices are designed to address the challenges of collecting information from and communicating with the victim of domestic violence, dating violence, sexual assault, or stalking, while meeting the confidentiality requirements in the rule. For example, conduct the intake session in a private room where the individual and staff person can talk without the risk of other staff or clients overhearing. Explain the PHA's information sharing policies. Communicate to the individual who in the PHA is responsible for handling questions or complaints about confidentiality. Provide adequate time for individual to review and sign forms. Post confidentiality notices in the intake room and around the PHA. Ensure relevant staff understand confidentiality policies and procedures through regular staff training. Post notices about the importance of maintaining confidentiality throughout the office. Direct staff to respond to third-party inquiries only after verifying that written client consent has been obtained. Clarify information sharing policies with referring or referral agencies and other services and business partners. maintain distinct phone lines for certain purposes, avoid using language referencing domestic violence or sexual assault in agency names, program names, organization names, and staff titles. Use a PHA post office box to receive written correspondence. Serve individuals off-site as needed or when appropriate. Provide interpretation and/or documentation translated in the appropriate language when necessary. Provide accessible documents or assistance filling out forms for individuals with disabilities. That concludes part 2 of the training. Please stay tuned for part 3.